Ladies and gentlemen, my name is Anton Shamatonov. I'm the managing partner of MAGENTA Legal law firm. We've been advising hundreds of investors in their conversion procedures for their depository receipts into Russian shares for more than 3 years already. Now we have launched the project of allocation of EVRAZ shares, and we'd like to share our expertise with you here. So without further ado, let's just go into this matter. So EVRAZ shares, save your investments, October 2025. If you're watching this video in December 2025 or later, then probably this is already not interesting for you because the deadlines are actually the end of November, 24th of November in particular. So first of all, who is affected? Actually, this presentation would be interesting, and EVRAZ matters would be interesting to the shareholders of EVRAZ PLC as of cutoff date of the 22nd of July 2025. This is the date. This is the date. Now, in terms of residency and citizenship, it is important both for Russian residents, Russian citizens, and for foreign shareholders as well. For Russian residents, actually, this is mandatory allocation, and we are not quite sure what the possible consequences of violation of this provision of the law would be, but probably there would be some currency control regulation issues and maybe tax issues. But yeah, actually, this is mandatory. Now, for foreign shareholders, this is the optional allocation. You may opt to do this or not to do this. However, there will be also some consequences. And since this presentation is mostly, of course, for foreign shareholders, since it is in English, we will speak about that a bit later. Now, for both Russian citizens and holders from friendly states, so-called friendly states, the shares should be generally credited to ordinary accounts, depot or brokerage accounts, wherever you open. For investors from so-called unfriendly states, which are basically EU countries, the UK, the USA, Australia, and many, many other countries as well, there is a list. If you're not sure which country it is, just give us a line and we'll advise you. So for investors from such states, shares should be generally credited to Type C accounts, which means that they would be actually frozen. There is a restricted regime, a lot of limitations. So yeah, they will be frozen until some developments in probably geopolitical situations and some changes in the Russian legislation. Many people ask us what should be done if we have several citizenships, if we have a Russian citizenship and a foreign citizenship, or if we have a citizenship of friendly state and another citizenship of unfriendly state. So the answer is as follows. If you have a Russian citizenship, you would always be regarded by the Russian legislation as of now as a Russian resident, as a Russian citizen, not a tax resident, of course, but for the purposes of this legislation, of this procedure and comparable procedures like DR conversion as well, you would be regarded as a Russian citizen. If you have two unfriendly citizenships, you're obviously regarded as unfriendly. If you have two citizenships, one of which is friendly and the other one is unfriendly, unfortunately, you would be regarded as unfriendly. Now, the last point about who is affected. This is basically for those who has purchased, for those who have purchased the shares or the certificates before the 5th of August 2022, because purchases after the 5th of August 2022 required the specific, very specific approval from the Russian Governmental Commission. We are not aware of any such approvals for EVRAZ shares, transactions. Such permissions are given for a lot of other transactions with securities, with dividends, in other issues, also for live in Russia, for foreign related foreign-owned companies. Such approvals have been given in the past, but we don't know such examples for EVRAZ. And as far as we know, no retrospective approvals are possible, or at least it would be extremely difficult to get such approval before the deadlines that we will discuss later. So basically, this is for those who have purchased the shares before the 5th of August 2022. Now, if we go to the deadlines, first date was actually the 20th of August 2025. It was the start of the procedure. This has already passed, obviously. Now there is a second deadline, which was a recommended deadline for the submission of the file for preliminary approval or pre-check of your documents by the registrar. It is not mandatory. You have the right to just skip this. But of course, your chances would be much higher if you use this opportunity to discuss the file that you have, since it's not very easy to prepare such a file. It is quite complicated. So there was a deadline of the 24th of September 2025. As far as we know, not many investors managed to submit the files before this date, actually. So our internal recommendation would be to submit the documents, the complete file, for such pre-approval at least before the 1st of November 2025. That would give at least a couple of weeks for the registrar to look through your file and maybe to give you some comments. They're not obliged to pre-approve. They don't have such commitment, but at least you would have a chance. The closer to the date, which is in the fourth point here, the 24th of November, the closer to the date you submit the application and the documents, the less are the chances that you will get some feedback and you would be able to change something, to rectify some defects, and so on and so forth. And so the final deadline, as you already understood, this is the 24th of November 2025. This is the date when all the documents must reach the registrar. After that date, they will not accept them. In 2022, when we were doing forced conversion procedures, in part comparable, quite a bit comparable to what EVRAZ wants us to do, the investors to do. So in 2022, during the forced conversion, the deadline was actually shifted for like 1 month. And instead of 3 months, the investors got 4 months. But the announcement about that was just about 5 or 6 days, if I'm not mistaken, before the expiration of this deadline. So we strongly recommend to stick to this deadline. There is no absolutely guarantees that any prolongations would be at place in the future. Now, just a couple of words about the EVRAZ, key facts and background. We're not sure whether you're already qualified and you know everything about what EVRAZ is. Maybe you have just invested some money into this position. So EVRAZ PLC is a United Kingdom incorporated company, which previously controlled major Russian steel and mining assets, with a key subsidiary, which is Open Joint Stock Company, or in Russian PAO, акционерное общество, публичное акционерное общество, Public Joint Stock Company, EVRAZ NTMK. NTMK stands for Nizhny Tagil Metallurgic Factory, which operates metallurgical plants, mining facilities, and related assets in Russia. And according to the official announcement, it is actually 67%. NTMK represents 67% of EVRAZ PLC's, UK's company value. So it's quite a lot. Then in 2023, the law, which has the very important number 470, you will hear it a lot maybe today, was passed, and it introduced the new concept, the new notion of economically significant organizations, ESO. Those who have some experience with Russia know that there are also strategic companies. This is a different term. This is a different law. This is not a translation issue. This is a different status, economically significant organization. And this year, in January 2025, EVRAZ NTMK was declared an economically significant organization. This law was therefore also became also applicable to NTMK, EVRAZ. And already in July 2025, this is where the date of the 22nd of July, which is the cutoff date, as I remind you, the previous slide, we spoke about that. 22nd of July 2025, Russian State Commercial Court, how they are sometimes called in Russia, arbitrage court, terminated EVRAZ PLC's corporate rights in respect of NTMK. So basically, the court said, now we will be under full Russian control here within the Russian infrastructure. And all the existing shareholders of EVRAZ PLC, the UK company, now either have to enter in the allocation procedure or they have the right to do this. Again, for foreign shareholders, they have the right to do this. This is what we are discussing today. In 2026, they are expecting that EVRAZ and TMK will probably be listed at Moscow Stock Exchange. So PLC will become sort of PAO, which is a public register company, just generally speaking. And one EVRAZ PLC share will be allocated into 2.689 shares of EVRAZ and TMK, which is in Russia. So there would be three categories of possible ownership of EVRAZ PLC, which would affect the procedure in general. The certificate holders, paper certificates, they were actually not quite widespread in the past, but at a certain point of time, they became a little bit more popular. You will see it later. Now, the other category is the owners whose rights are already recorded in the Russian infrastructure with NRD or NSD, National Security Depository, Russian, actually sanctioned central depository in Russia. And the third category would be the owners whose rights are recorded in foreign infrastructure, or they are just foreigners holding certificates of EVRAZ PLC. Certificates are the first point. So those investors whose rights are recorded in foreign infrastructure, in their depositories, online brokerage accounts, and so on. This is probably the most vague, the most popular category. Now let's speak about allocation mechanics. As I said, conversion ratio is 2.68. What is important? Shares of EVRAZ PLC will remain intact. So basically, you will still have those shares. At least as of now, this is how everyone understands the procedure. Nothing different is written. This is not exactly the conversion as it used to be with regard to depository receipts, which were supposed to be sort of terminated to just extinguish. But we certainly understand that these shares of EVRAZ PLC will probably have a very big drop of value. As we said, 67% was the value of the Russian assets in EVRAZ PLC. As we know, in June, or at least this summer, some of their other subsidiaries were already sold, like Atlas. So you may search for this information and check what is the status of the British company or the UK company, but probably the drop of value will be very high. Of course, we understand that there is no trading on a stock exchange, but when it happens, when it becomes unblocked, hopefully sometime, this may become just a shell company, or at least close to that. No financial advice here, just legal, sorry. So allocation will require submission of application and full document set to the registrar. Please note that there is no automatic allocation. You need to be active here. The documents need to be submitted to the registrar, which is ROST, which is ROST, stands for ROST in Moscow, Russia. It also means that the investors would have Russian infrastructure access. You would need to have an account, securities account, custody account in Russia. Basically, according to the Russian law, we don't speak about your local law. and your status and regime of the papers, there will be no share purchase agreement, so there should be no tax on acquisition, because the allocation occurs just by virtue of law and based on the court decision, which is obviously recognized in Russia. But yes, please do assess your sanctions risks in your respective jurisdictions. It will be different in every jurisdiction. We have already received requests from our multiple clients on this subject. We are not lawyers in every jurisdiction. We're not experts in every jurisdiction. We are always happy to give you a preliminary advice on sanctions on the UK, sanctions, EU, the US sanctions. But of course, we are not certified lawyers in these jurisdictions. So you might wish to speak about that with your lawyers in your respective jurisdiction, because it will be different. It will be different. Please make sure, because some of the companies like Ross, they are sanctioned in one country, not sanctioned in another country. If you open an account with, for example, Cifra broker, this is one story. It's not blocked. It's not sanctioned. If you open a Gazprom bank account, that may be a violation of sanctions in the US, for example. So you need to check that for your particular jurisdiction. Now, a very interesting note here, and a special slide just for this point. We will just briefly discuss the procedure, and we have already discussed that it must be a set of documents which is provided to the Russian registrar. You would generally be the shareholder if you allocate the shares and remain the shareholder, but now the shareholder of the Russian company, EVRAZ and TMK. But there is a special Appendix 4 procedure. Appendix 4 means the Appendix 4 to the EVRAZ regulations on allocation that they have adopted, that they have published. It is definitely not a law, but this is something that is based on the law, and this is what EVRAZ and its registrar ROST stick to. And anyway, this is, as again I said, this is based on the federal law 470. It's written there directly. It is set out there in a special article that foreign investors might use the option of a special material deed transfer of the shares to Russian citizens. You would say, why should I do this? I can't do this because of the sanctions. Why should I do this? Why should I risk? You might be interested in this option because if you are an investor from unfriendly jurisdiction, as we said, your shares most probably will be blocked on the special Type C account. If you, however, use this Appendix 4 procedure, which is quite unique, and it's really no precedence there in the past for such procedures. So, of course, we need to give you a disclaimer that the law remains unclear. There's no practice, no decisions of the courts. It's just written in one legal provision of the article in the federal law 470 and in this Appendix 4 of EVRAZ regulations. So basically, you can do this. And we think that after that, the shares would be on the account of such a Russian citizen. And Russian citizens don't have Type C accounts. They would basically have their shares on an ordinary account, which is a big advantage, because if in 2026 EVRAZ becomes listed at MOEX, at Moscow Stock Exchange, and the transactions become possible on the open market, they probably would be able to be sold, would be eligible for sales, right? So you probably would wish to consider this mechanism. When we speak about notarial deed, certainly in the UK, this term is a special term. It means a special form of the document. Here it is a translation point. In Russia, it's basically the notarial application, notarized application. So this form is not established by the law. It's not established even by the Appendix 4 or EVRAZ or ROST. But we have already prepared such form. We have pre-confirmed and pre-proved it with some of the notaries and with the registrar ROST, which is even more significant. So for some of the clients, we already use this, and we hope that would help maybe some of you as well. Now, just several words very fast about the certificates and the shares. What is the difference if both of them seem to be something that gives you corporate rights in the company? Your dividend interest is confirmed by this. Not so easy, because the share certificates became widespread only enough in August 22, when basically a computer share, the register keeper seized, acting as register based on sanctions, and EVRAZ PLC itself took over its register and started issuing such certificates for their shareholders. And certificates dated before 5th of August generally are accepted as proof of ownership within the allocation procedure as such. You just need the certificate and some other documents as well within the set, but you don't need to show all your history of transactions and holding. But the certificates which are dated after 5th of August require additional notarized documents which would confirm that the purchase itself took place before 5th of August. So there are cases when you buy shares, you sign a transaction with the seller before the 5th of August, and then you start these registration procedures to get the certificate in the paper form. It may take some weeks or sometimes even months maybe for you. So the dates would be different. And we already have such clients who have, for example, a transaction in the beginning of 2022 and the certificates in August 2022. Some of them are the 3rd of August and the others are the 5th or the 6th of August or the 8th. So that would be different regime. For those certificates which are issued after 5th of August, you need to prove that you bought the shares before the 5th of August. Without that, you would probably get a rejection of a denial for the allocation. Now, for the electronic shares, it's a bit different. These were mainly held, and that was an ordinary procedure. They were held in CREST, the UK settlement system, until August 22, or via brokerage pension accounts linked to such system. So here, you would need to show the purchase date before 5th of August 22, and also holding after the August 22 till the decision of the Russian court this year, 2025, till 22nd of July, 2025. So this is a bit more. You would need to do this notarial inspection. Sorry, I may be having some difficulties with my face, maybe in front of the text, but notarial inspection is required here. You will not be able to skip it. And now just the final part. We spoke about some particular points here. I think it was important. Obviously, we don't want to speak about all the details about the list of documents. This is quite a lot. If you just contact us, we give you much more information in the emails. Why Magenta Legal? Because we have a lot of lawyers with international and language background. They speak English. Some of them speak German, for example, if you're from German-speaking countries. We have supporting staff. We have certified translator in our team. We have a partner translation agency, obviously, because the amounts, the volume of the file can be sometimes very, very big. And we worked with them for more than 3 years already, for the depository receipts conversions, which have similar specifics, and it helps, of course, with preparing the documents. They have their drafts that can be sometimes faster. They can give us discounts compared to market of translation. We have also partner notaries. During these years, we worked with many of them. We chose the best who work quite fast. They prepare good notarial inspection for your brokerage accounts. They have very good expertise, and we have checked the results. We have a lot of successful conversions with their protocols, so-called protocols of online inspection or brokerage accounts. We also have possibility and opportunity to use logistics via Europe. We have partners in Europe. We have a branch. Actually, Magenta Legal has a branch in Serbia. We can arrange payments through Europe, of course, as well. So it can be very useful as well. As I said, a lot of experience in DR conversion and our legal rankings as well. This is just for your information, some of the stats that we have done in the past for depository receipts programs. You can contact us via Telegram, via email. You can also visit our website. We have a special dedicated web page for capital markets, for the depository receipts, and now also for EVRAZ allocation shares. Maybe that would be interesting for you. Please do contact us. So thank you very much for your attention. I hope that was interesting for you, and good luck. Hope you will get the allocation successful. Goodbye.